What starts as a routine probation hearing quickly turns into a harsh reality check for two defendants standing before the court. One woman, already given multiple chances, now faces the consequences of repeatedly violating probation, even after being offered treatment programs and support. Another man, with a history of felony convictions, is hoping for leniency despite already serving time for the same type of crime. But this judge isn't here for excuses, only accountability. As emotions rise and patience runs thin, the courtroom shifts from second chances to final consequences. The real question is, how many opportunities is too many before the system decides enough is enough?
House, you may proceed.
Judge, as the court knows, this is Ms. Johnson's third motion to revoke. She's been given opportunities in the past to comply with ISF, MRT, and some mental health counseling. She hasn't taken advantage of all those opportunities. She has some CPS cases going on. She's kind of doing double load casework. She's got some CPS cases in Harris County. She's taking some classes through there, and that had been her focus up to now, is trying to get her kids back. I've discussed this current motion with her. She understands that the options the court has this morning are to book a probation center to prison, or to try one more time and get her some help through either ISF or SafeP. In discussions with Ms. Johnson this morning, I think the option that she would rather do is to ask the court for some mercy and give her the lowest amount of time in prison possible. We would request something in the neighborhood of 2 to 4 years. She, at this point, doesn't feel that she needs a drug treatment, and the ISF program is this thing that, well, she was removed last time because she's pregnant. She's not pregnant right now, so I think this would be the perfect time for her to get ISF and get that help. But she tells me that she doesn't want it. She would just rather go to prison and get this case over with.
Ms. Malfino?
Judge, I concur with Ms. Lopez. Obtained a PSI. It's very thorough and goes through every opportunity this individual has been given by the court. It's a shame she doesn't want the help. Really could help her. I mean, if she was using last time while she was pregnant, she's obviously somebody who has an issue that needs to be addressed. But if she doesn't want the help, I guess she shouldn't take up someone else who wants the help spot. And so I think revocation is appropriate with something in at least in the mid-range.
Let me look real quick. Let me see what this.
Looks like she had one prior MTRP and was given 120 days sanction at that time in 2023.
I mean,
the facts of the underlying case, I think she threw a bottle at a girl and waved a knife at another. We pled on dismissed from originally. I think nobody was injured, judges, just threats basically.
Well, she threw the bottle attempting to hit someone else, but it hit someone, but it hit someone else in the head. Well, there's no accidentally. You meant to hit somebody with it. You just hit the wrong person.
This is a critical turning point. The judge is no longer evaluating just the violation. She's assessing pattern behavior. Ms. Johnson has already been given multiple chances through probation, treatment programs, and even reduced consequences, but the repeated violations are now working against her. In court, respect and timing matter just as much as facts. Interrupting the judge at this stage doesn't just come off as frustration. It can directly impact sentencing. The judge even makes it clear, continued disrespect could increase the prison term. This moment highlights a harsh truth about the legal system. Once a defendant is seen as non-compliant, every action in court starts influencing the final outcome. Do you think the judge is justified in reacting this strongly, or should more weight be given to her personal struggles?
Jail incident reports are ridiculous, and then you want to come in and say, I just want to get this over with, give me a couple years in prison, which you probably have credit for, which is absolutely not what I'm going to do. Give me just a second.
Now the judge is weighing everything. The original charges, repeated probation violations, failure to complete programs, and even behavior while in custody. What stands out is that this is no longer about a single mistake. It's about a consistent pattern of missed opportunities. The defense asked for a lighter sentence of 2 to 4 years, essentially hoping for mercy. But the judge clearly sees this differently. From her perspective, prior leniency didn't lead to change, so a stronger consequence is now necessary. This is where the justice system shifts from rehabilitation to punishment. When someone repeatedly fails probation, courts often conclude that community supervision is no longer effective. The tension here is real, because everyone in the room knows that the next words from the judge will permanently change Miss Johnson's future.
The written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Good luck to you. You can go back with the bailiff. Ms. Holmes, you may proceed.
Thank you, Your Honor. As the court can see, Mr. De La Rosa is an amputee, in which he suffered from injury a few years ago. Your Honor, we're requesting if the court would consider probation. I believe that Mr. De La Rosa would benefit from being on a mental health caseload as well. He does suffer from some mental issues that I feel that would be beneficial if he could receive care through either MHMR or Spindletop. He understands that he does have prior convictions, so as a convicted felon, so he cannot possess a firearm. And he understands that moving forward, no matter what situation he's in, he cannot have a firearm. Your Honor, he does have 2 children that he would like to be better involved in their lives. One of the main issues that I see in the PSI is education. He has a 6th grade education. I think it would also benefit if he would be allowed and participate in the GED program through the probation department as well, to help him to develop some skills so that he can make better decisions and get his high school, at least minimum high school equivalency. There isn't much history in regards to substance. With regards to substance abuse, looks like maybe alcohol that he drinks on occasion. And he has no problem, it says in his recommendations, to avoid any association with the co-defendant, Ashley Faye. And as I stated, Your Honor, he would be willing to adhere to any referrals or treatment plans or directives that probation may recommend. And so we are requesting probation.
Thank you, ma'am. Mr. Nichols?
Your Honor, he has 3 prior felony convictions, one for being a felon in possession of a firearm, one for aggravated assault with deadly weapon. He should have been habitual. I took into consideration his health issues when I made the offer of an 8-year cap. I don't know that he deserves any more consideration for what has happened to him. You see his gang history, his criminal history. I think 8 years is appropriate in this case.
And I'm sorry.
Mr. De La Rosa, you wanted to say something?
I do got priors now, but I don't know like juvenile stuff like that.
So in 2015, you were not a juvenile.
2015, that when that conviction was like, I think 7 years.
That was your conviction for unlawful possession of a firearm by a felon. And you got a 2-year sentence.
Yeah, no, but I did my time, and I did parole. I did good behavior.
Right. So you should have learned, not that you can't possess a firearm. I mean, and Ms. Holmes is doing the best she can, saying that, you know, you understand and that you can't possess a firearm, but you've already gone to prison for that. So
I was at the wrong place, wrong time. Now, I mean, it wasn't my position due to the fact that I am a felon. I'm not denying it, but you know, what I'm saying, I would deserve I feel like a second chance or something.
well,
I always keep like I want to get thrown in prison, come out when I'm 38, something like that.
well, and I understand. Well, and here's the thing, Mr. De La Rosa, nobody wants to get thrown in prison. And what I do today isn't anything that I'm doing. It's where you've gotten yourself with your history since you've been a juvenile into being an adult, knowing that you cannot possess a firearm. You've got 3 prior felony offenses. One was when you were certified as a juvenile, that first one. And then if you didn't understand the law about deadly weapons, you should have, or carrying a firearm, you should have back in 2015. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement I followed, so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, we know this now. I'm required by law to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right.
This courtroom session delivers two powerful outcomes that highlight how the justice system handles repeat offenses. Ms. Johnson, after multiple probation violations and missed rehabilitation opportunities, receives a 12-year prison sentence, showing that repeated chances don't last forever. Meanwhile, Mr. DeLoss faces 6 years for unlawful firearm possession, despite already serving time for a similar offense in the past. In both cases, the judge emphasizes a key principle. Prior convictions and repeated behavior carry serious weight in sentencing decisions. The court isn't just judging one moment, it's evaluating a history. These cases serve as a clear reminder that ignoring past lessons often leads to harsher consequences down the line. If this case made you think about second chances and accountability, drop your opinion in the comments, hit like, and subscribe for more real courtroom breakdowns.